I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for another round of open government lessons. During this class, you'll learn about police misconduct records and how you can access them under your state's public records law. During this round of classes, we'll be joined by an attorney to explain how the law works, as well as a local journalist who will share their experience requesting these police records. If you haven't already, please view our previous classes on public records, open meetings, and state court systems. The lessons they provide are all cumulative, starting you off with the basics and then gradually addressing more nuanced areas of law and journalism practice. The classes are state specific and provide practical, step-by-step lessons you won't find anywhere else. You can find them all in our FOI guide at NEFAC.org and on our YouTube channel, 5 Freedoms. Before we begin, I want to recognize the Estate of Gloria Negri for its support of these classes. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. Thank you also to the Rhode Island Foundation and the New England Society of News Editors for their continued support. And a big thanks to you for taking the time today to learn more about how to keep government open and accountable in your state. Now, here's NEFAC's Emily Sweeney to introduce you to today's instructors.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you for joining us for another round of open government lessons brought to you by the New England First Amendment Coalition. During this class, you're going to learn about police misconduct records and how, if at all, you can access them under your state's public records law. So with us today is Liam Elder Connors. He's Vermont Public's public safety reporter focusing on law enforcement, courts, and the prison system. And we're going to kick it off with Harrison Stock. He's a staff attorney at the Vermont ACLU affiliate, where he litigates a range of civil rights and civil liberties matters in state and federal court. Thanks so much for joining us, guys.
Thanks so much, Emily. It's great to be here. And also great to be in conversation with you, Liam. This is a topic close to my heart, and really appreciate NEFAC putting this together. All righty, so I think we're hoping to make this a little bit more of a conversation. So really quickly, just going to run through a little bit of the legal landscape and some of the considerations that might come into play when you're trying to access police misconduct records through our Public Records Act. And so we're just going to do a couple things really quickly. One, we're going to talk about the general rules for accessing police misconduct records and talk about some of the most common obstacles to seeking them through our Public Records Act. Then we're going to talk about any techniques you might be able to use for records that are even less accessible. Those are ones that are designated specifically to be confidential by law. And then last, I just want to touch really briefly on a couple of avenues you might pursue if you don't have access to particular investigative files about misconduct, but you want to get at some of the underlying facts or try to get a lead on potential misconduct. So really quickly, just police misconduct records generally. Here in Vermont, we would have what I would describe as a qualified right of public access to police records. That means that police records are treated just like any other government public record. There is not a general carve out for local police records. There is not a specific rule that goes to police records. Instead, they are presumptively disclosable, but subject to any of the traditional exceptions in our Public Records Act. And the largest barrier by far to accessing police misconduct records, essentially every time I've requested any records within this sphere, I've run into exemption C7, which is for personal documents relating to an individual, including information, any files maintained to hire, evaluate, promote, or discipline any employee of a public agency. Again, this isn't specific to police in particular. This applies to any employee of a public agency, but this is frequently the one you run into first when you're accessing, you're requesting police misconduct records. And I want to just talk about this exception in a little bit more detail because you're likely to run into it. The first thing to note is that it's a personal privacy exemption that protects personal records, not personnel records. And the reason I say that is you'd be surprised to see how common it is to request misconduct records and to have a department come back and say, well, these are personnel records and basically everything in an employee's file is off limits. That's simply wrong. The exemption only goes to personal files, which the Supreme Court has clarified are actually quite narrow. They're documents that reveal intimate details of a person's life, including any information that might subject the person to embarrassment, harassment, disgrace, or loss of employment and friends. And so that's actually a very narrow category of records within a personnel file. And so the vast majority of things in an employee's file, you should be able to get access to. The other thing I want to point out about it is that the Supreme Court has been clear that this is a type of exemption which requires redaction of withheld information. So this is not a basis for an agency to withhold a record as a category or a record in full. If there's information that falls within this exemption, the agency or the department is entitled to redact that information, but cannot rely on this to withhold the entire record unless literally the entire record contains information that would reveal the intimate details of a person's life. The last thing that is important about this exemption is that it's a balancing test. The court has been clear that in order to determine whether or not something should be disclosed, the custodian has to balance the personal privacy interest of the individual against the public interest in disclosure of the information. That's both an advantage and a disadvantage if you're the person seeking these records. It's an advantage because it gives you essentially a register or grounds to explain why you are entitled to the records, and essentially a landscape on which to have these disputes. The reason it's a disadvantage is because when you're balancing two fairly abstract values, it's always going to be a little bit of a judgment call. And so there's some discretion and some, I think, some reasonable disagreement about whether a record falls on the side of personal privacy or the public interest in disclosure. And anytime you are facing down this exemption, I want to point folks to a particular case, which is Rutland Herald versus City of Rutland. This is a 2013 Vermont Supreme Court case that kind of fleshes out some of the considerations that go to the particular weight going to an interest in privacy versus an interest in public disclosure. And what the court said is there's essentially three factors. There's what's the significance of the public interest, what's the type and gravity of the consequences to the invasion of the individual's privacy, and are there other ways to get the information? And the reason that this case is particularly important, I think, if you're requesting records, is because it concerned a number of employees at a police department who had been caught watching pornography on their work computers, including child pornography. And one of the things that happened is that the department sought to redact both the individual information about the officers as well as the punishment they faced, saying that, yes, the fact that the officers were caught doing this is perhaps an issue of public interest, but there's really no public interest in the particular details about the way that they were disciplined or their identity. And the Vermont Supreme Court said, no, that's actually not right, that the way that the department reacts to individual instances of misconduct, including who the individuals are and the discipline imposed, is itself a matter of public interest because it can tell you about the way that the department is disciplining its employees or kind of handling these incidents. I think this is a great case for sort of showing why things that even don't have might not be sort of directly and intuitively matters of public interest for police misconduct do in fact have cut in favor of disclosing records. And so basically anytime I'm having a fight where this record comes up, pardon me, I'm citing this case, I'm looking to it, and would recommend that folks take a peek at it because I do think it gives a lot of very helpful language for what types of considerations bear particular weight. That's all for records that are just for traditional, presumptively disclosable records that are running into a judicial exemption. While there isn't a general carve out for police records, there is in the Public Records Act a kind of freestanding exemption for any record that is designated confidential by law. And unfortunately, there are a number of non-Public Records Act statutes that create specific carve-outs for particular types of misconduct records. Two of the most prominent ones are one that says that files within the Office of Internal Investigation for the State Police Advisory Commission should be confidential, as well as records of the Criminal Justice Council. And the reason I want to call attention to this is because just because these records are designated confidential by law does not necessarily mean that there's no way to get them through a Public Records Act request. And folks, anytime they're encountering a particular specified exemption like this for a particular office, should look really closely at the language of the exemption, because there may be opportunities to trace the records back to essentially their original source and request them from that custodian. And there's a recent case coming out of the Superior Court, which I think sort of highlights how this works. There, you had discipline records from an officer who was employed by the town of Stowe that were sent to the Vermont Criminal Justice Council. When journalists went to the department and said, we want records about this particular type of misconduct, the town said, well, we're prohibited by law from giving them to you because they now reside essentially with the Criminal Justice Council. And what the judge said is that's not right. Just because a record eventually makes its way to an office which is exempted from disclosure doesn't mean that all instances of that record, wherever they may originate, are necessarily exempt. And so by requesting this from the town, the record had to be disclosed. There's a nice little juvenile quote, "Who watches the Watchmen?" for your classes out there too. But that logic of the opinion really should apply to any particular exemption that is going to a particular office. Just because a record may eventually end up there does not mean that wherever it exists, it's necessarily confidential. So it can be helpful to go back and sort of see where the record has been, who else might have a copy of it, or which office it originated from. Really briefly, I also want to talk about techniques for uncovering or getting at police misconduct, even if you are unable to get at a particular investigative record that maybe documents that misconduct. The first one, which is I know something that Liam's going to talk about a little bit more, are Brady letters. These are letters that are maintained by prosecutors, state's attorneys in Vermont that highlight credibility issues for officers. These are required disclosures under legal ethics rules that basically when someone is being prosecuted for a crime, if the officer has documented issues about essentially their credibility, whether or not they're trustworthy, that has to be disclosed to the criminal defendant. And because they are maintained in these offices, you can often get them through a Public Records Act request. We've been successful in getting a number of them. They're of somewhat limited value in that they often don't have a ton of detail about the underlying facts that led to that credibility determination. And of course, not all officer misconduct is necessarily going to be the kind of trustworthiness issue that would appear in a Brady letter, but it's a great starting point. And it often has the name, in fact, it always has the name of the particular officer. So it can be a great place to look if you're trying to get a lead on whether or not there are files somewhere about something a particular officer has done. And the last thing I want to talk about is body-worn camera footage and what to do if you suspect that there is body-worn camera footage that maybe documents a particular instance of police misconduct. And the reason I want to bring this up is because as journalists or transparency advocates know, it can often be difficult to get body-worn camera footage from police departments. And some of the considerations that make that true in a typical case, I actually think are lessened in a case of police misconduct. Typically, it can be difficult to get these records in Vermont because there's an exemption for records going to the investigation for crime. This is C5, records dealing with the detection of investigation of crime. In statute, it says that Vermont's exception basically tracks exactly a similar exemption in the federal FOIA. But body-worn camera footage is kind of a difficult fit for the investigative files exemption, and that it's not really an investigative record at all. It's usually merely a piece of evidence. And more than that, the underlying considerations, the values that this exemption is really supposed to protect just don't really apply when it comes to officer misconduct. Usually the rationale for not disclosing body cam footage is that it would alert a particular, not for body cam footage specifically, but for this record more broadly, the justification is that we don't want folks who are the subject of a criminal investigation to necessarily know that they're under surveillance or to be able to find out kind of exactly what the police know about the potential crime, because it might facilitate them covering it up in some way, destroying evidence, something similar. When it comes to body-worn camera footage that is documenting what the officer is doing none of those rationale really apply, because there's no question that the officer who's wearing the camera knows that they're being recorded in some sense. And unlike your hypothetical criminal defendant in a traditional case, the officer already has access to the camera footage in most instances. And so it doesn't make sense to say that the individual who you're investigating for potential misconduct, who already knows that there's some recording of it, and probably already has access to the footage, that any sort of legitimate value in law enforcement is being furthered by letting them have access to the footage, but not the public. This is a relatively untested issue, I think, in a number of courts, but particularly here in Vermont. So I flagged this just in case it comes up. We'd certainly be interested if folks come across this, but want to plant that seed for folks who are out there in case they confront this, because I do think there's some opportunities to make some good rules here. That was just a sort of a quick overview. I'm going to turn it over to Liam now, who's going to get into some more detail about some of the practical considerations that folks can run into when investigating these instances on the ground. And so with that, I'll turn it over to you, Liam.
So what I'll be doing is going through some stories that I have reported throughout my career dealing with police misconduct, and sort of walk through a little bit on how I got them, how I used records, or how I used the lack of records to get to a story. And I'll also show some examples of the public records requests I made in those stories to get the records, and then talk a little bit about just some general experiences I've had. And I might even have some questions for Harry about some of the law as well. So this first is a story that I did 4 years ago now, about a officer in St. Albans who pepper sprayed turned out to be an 18-year-old who was handcuffed and shackled in a holding cell. And this was a case where no one knew about it when it happened. It happened quietly. The officer was resigned in the middle of the internal investigations, and the AG, the Attorney General's office at the time, reviewed that use of force and said no criminal charges. So it happened quietly, kind of went away, nothing really came of it. And the way I came about it was doing some general reporting into how often the Attorney General's office files criminal charges against officers who have used force, because in 2020, there was an officer at St. Albans Police Department, same place where this pepper spraying incident happened, where an officer punched a handcuffed woman who was in a holding cell, the same holding cell where this teenager was pepper sprayed a few years prior. And so I was just sort of curious to know if the AG had, this was looking, kind of doing my normal digging, and I asked for a list of all the cases that the Attorney General's office had reviewed involving officers' uses of force, which includes when an officer or a police officer shoots a suspect. So I got this list here. So that was the first records request I did for the story, was just give me a list of all the cases you've reviewed. And so when I looked at it, this list here, I recognized a lot of the names because a lot of them were what they call here OIS, which is officer involved shooting, which is when a police officer shoots somebody. That's just the terminology that law enforcement will use. And knew most of these. They were mostly high profile cases. The last one was the individual who had been charged with punching the woman in a cell. But then I saw that in 2018, a year prior, there was another officer at St. Albans who had been investigated for a use of force incident. There was no prosecution, but I'd never heard about it, and I was curious to know a little bit more. So I made a records request for all the records related to that use of force investigation, including the videos. So this was just sort of the records request that I wrote for it. And what ended up happening was I didn't get the records of their investigation because they went back, they looked at the records, and they decided to reopen the criminal investigation into this former St. Albans cop, because the Attorney General at the time told me that he thought that he got the review wrong and wanted to go back and look at the case. I was able to get some details about what happened through interviews, but essentially what happened with this is I didn't get any records, but the lack of records sort of led to getting into the story. And eventually the AG's office brought criminal charges against this officer. Body camera footage has since been released, and that officer pleaded guilty to simple assault. I think it was just last year that happened. So that case is resolved. But that was one where kind of early in my career of looking at issues of police misconduct where I didn't have a lot of records and I sort of was having to go on a lot of nothing and sort of use that lack of records to find things. So just because someone doesn't give you anything doesn't mean you can't get somewhere. And I think in situations like that, holding out and, you know, demanding on the record interviews, demanding information on the record can be useful to find out a little bit more of what's going on. All right, so I'm just going back. So these next two stories are related to what Harry was talking about with Brady Giglio letters. So this one story, you know, I was just looking at all the Brady Giglio letters that have been filed in a year. The second story was a little bit more focused on one department. And with the Brady Giglio letters, like Harry was saying, there's not a lot of information in those. But when I requested them, I was at least, sorry, my dog is having a moment there. But when I requested the Brady Giglio letters, I was at least able to see all of the officers that might have had potential internal investigations into them. And in fact, in some of the Brady letters, they actually referenced the internal investigation for the reason why they were issuing the Brady letter. And so I would get the Brady letters, read the Brady letters, see that there was an internal investigation referenced in that, and then request that internal investigation. And I did actually made those internal investigation requests to a few different sources to try to deal with the issue that Harry was talking about, where sometimes a record's withheld and they say this is designated confidential by law, whatever. So I requested those records both from the state's attorney's offices that wrote the Giglio letters, but then also the individual departments where those internal investigations originated from. And in actually all of the cases, and this was the first time that it happened, I actually got all these internal investigations, which I'd never been successful in getting internal investigations before. But when I was doing this reporting, I was able to get those records, and they were incredibly helpful in sort of fleshing out the details of what was the alleged misconduct that led to a prosecutor determining that there was some, you know, untruthful, there was a truthfulness issue with the particular officer. And so the story ended up being kind of looking at these 13 cases and looking at a number of the ones with the internal investigations, like what actually happened, like, and how different counties have sort of different, in some ways, almost levels of what rises to misconduct, where they'd write a Brady letter, just sort of trying to get at some of those disparities around the counties. And this second story with half of the police with potential credibility issues in Northfield that came later as part of my reporting is just regularly checking on Brady letters to see what new ones have been filed. And as I was doing that, I was looking at my spreadsheet and saw that, you know, Northfield's a pretty small police department, or it is a small police department, and it's only got 6 or 7 officers, and 3 of those officers all had Brady letters. In fact, one of them had recently left the department after he'd been chief of the department, and Brady letter got issued, internal investigation. He left that department, hopped over to Northfield, and so that was sort of a follow-up to the follow-up. But I think it also highlights just a good, you know, it's good to stay on these things and make regular records requests for things like Brady letters, and then following up with records requests from those. So this is the records request that I use for Brady Giglio letters, just for this particular one. All Brady Giglio letters filed by 14 state's attorneys between a time frame. And in my experience, they're pretty quick in getting those back, and I make those requests to the Department of State's Attorneys and Sheriffs, which is the department that kind of oversees, or it doesn't oversee, but they're sort of the clearinghouse for these things. This is a similar situation where Brady Giglio letter sort of opened up this case. I don't have too much to say on this one other than a value in when you're making the request to ask for all audio and visual material that is part of the internal investigation. In this one, I got audio of this police officer who is accused of using excessive force. I got video or audio of him being interviewed by another detective about the incident, and that was just some very useful quotes and things to actually be able to use in the piece to try to show a little bit more of what was going on. And you don't always get these things. Sometimes I've been denied, but it's always good to ask because you never know. Sometimes you'll get something. And that's one issue I found, is that the inconsistency sort of between departments around the state of who will give you what, how quickly they'll give it to you, and like how much you might have to fight to get it. So that's generally been my experience. And for this, I just asked for all the materials related to the internal investigation into the officer, and I got, a link to like a share folder. So generally, I think when doing this, making regular records requests are really helpful for things like Brady Giglio letters. Just doing that every, it doesn't have to be every month, but maybe every quarter, doing that just to sort of check in. There's also the Act 56 register, which is the Act 56 was a law designed to sort of track and regulate law enforcement better, and the Vermont Criminal Justice Council, which is the sort of professional regulation body for law enforcement officers, has regular meetings where they discuss whether or not an officer should be certified. And so it's good to check that register to see when meetings are coming up, if they're going to be discussing decertification. And sometimes those notices of hearings, actually frequently those notices of hearings will contain a lot of information about the alleged misconduct that's gone on. They'll sort of lay out facts of the case. And if it's a contested hearing, then it essentially is a mini trial where the officer will be defending their conduct and the state will be making a case for why that officer should suffer a particular penalty or have to face a certain consequence. And then lastly, just staying organized. I'll see if I can open it up, but just here is just a spreadsheet that I made when I did my initial Brady Giglio reporting, just, when the letter was filed, who's the state's attorney, what county, what department is that person in, who's the officer, and then a little description of what the incident was, and as well as links to any coverage of it. This line here was just sort of looking at whether or not that incident had been publicized already, which is just sort of helpful for me to keep track of. So yeah, that's what I got, and I think Carrie and I are both happy to answer some questions or talk a little bit more about any of this.
I want to thank everybody who tuned in for this session and encourage everybody to check out our previous classes on NEFAC's website, nefac.org, and on our YouTube channel. Liam, Harry, thank you so much for joining us and leading us on this session. It was very educational. I know I learned a lot. And yeah, thanks so much.